Welcome back. A full bench of 3 judges will deliver judgment on Monday in President Cyril Ramaphosa's urgent application to halt former President Jacob Zuma from taking any further steps to his private prosecution bid against him. The Gauteng High Court in Johannesburg heard arguments on Thursday from lawyers on behalf of the president, the former president, and the National Prosecuting Authority on the matter.
Former President Jacob Zuma is accusing his successor, Cyril Ramaphosa, of failing to act in a matter involving advocate Billy Downer and journalist Karen Moon, and as accessory after the fact, following the two allegedly having leaked Zuma's confidential medical information during his arms deal trial. Zuma further accused the NPA of being dishonest in relation to the issuing of the National Prosecuting certificates. Advocate Ngwako Mayeneche, representing President Cyril Ramaphosa, argued that the president's rights would be trampled upon in the private prosecution bid launched by the former president Jacob Zuma. Mayeneche told the court that the head of state has a right not to be hauled to a criminal court, as per the summons issued by his predecessor. Advocate Dalimpofu, on the other hand, representing former President Zuma, who opposed the application, told the court, amongst others, that the matter was not urgent and that the president could defend his case in court on the 19th of January 2023 as directed by the summons. Meanwhile, the NPA refuted claims that it shielded the president through its statement when it clarified the issuing of the National Prosecuting certificates. The judgment is expected to proceed at 9:30 in the morning on Monday.
Well, now let's get analysis. We're now joined via Zoom by I Elton Hart from the University of Johannesburg's Law Clinic. Thank you so much, Mr. Hart, for your time. What are we likely to see happen tomorrow? I mean, do you think that the interdict will be granted that will ultimately prevent former President
Nati, I don't know if you can hear me, but if I got your question, it is more or less, as I said earlier on a previous occasion, is that one would get a situation where this is like a matter of interpretation of the law. And for me, there was good arguments advanced by both set of counsel from the former president's side and as well as the current president's side. So we might be seeing there, because the president was arguing that he's not supposed to, and that's like what we call preemptive litigation, not to stand trial in a court. But in the CPA, there's provisions if you have a problem with the charge that's leveled against you. On the other end, the former president argued that if the court grants this interdict to the president, it will set an unprecedented piece of case law there that individuals can actually now come to court and say, but I'm not willing to appear in court, give me an interdict. So that is what we're looking at currently.
Essentially lawyers that were representing the current president, President Ramaphosa, on a Thursday. Now, their argument is basically saying that there is abuse of process by the former president, Jacob Zuma. I'm not sure if you can hear me, Mr. Hart, but what's your analysis on that, and does it hold any merit, particularly as it relates to, the Criminal Procedures Act, as it applies to the National Prosecuting? I want you to explain that and elaborate a little bit further as you respond to your question around that.
Onathi, I don't think it's an abuse of process because the Criminal Procedure Act does make provision for private prosecutions. The only thing is that when a person institutes private prosecutions, there's certain procedural and statutory requirements that needs to be met. Has the former president met those requirements? I think so, because firstly, you start with a certificate, and then there was issues pertaining to that. The current president is not mentioned in the certificates. Then the NPA came, and they clarified the position to say that anybody who has been mentioned in the affidavit of the complainant as an accomplice, a co-perpetrator, or an accessory after the fact, that is the persons that should then be looked at in the private prosecutions. And then the president is coming now from his side and saying, but he was not properly cited and there was defects in the summons. Now we know that this is a high court, so there is certain procedural requirements that a summons needs to meet if you look at the uniform rules of court. So if that has not been met, then the summons is defective. Then the court has no other option but to then throw the case out and say, but the president was not properly summoned. On the other hand, the former president then said, we did not summons the president. We summoned Mr. Cyril Ramaphosa to appear at the private prosecution. So that was the two prickly pears, because here the president opposed the application, and then the person who is actually instituting the private prosecution, the former president, saying, I did not institute private prosecutions against the president. I did against Mr. Cyril Ramaphosa, and that's the person that needs to come to court on the 19th. So now it will boil down to how the judges interpret this, and bearing in mind that there is the rules of court, which is the uniform rules of court, as well as the CPA that needs to be read in conjunction with each other to see if the certificate was issued properly, met all the requirements, and also if the summons meets all the requirements that a summons should meet in terms of the uniform rules of court.
So that would mean then essentially if it does go against Cyril Ramaphosa, he will then definitely be dragged into appearing on the 19th of January into that criminal court.
Definitely so. If the court, if the full bench is of the view that the summons, there's no errors or defects in the summons, and the nolli prosecute certificate is valid, then the statement that the NPA made that everybody mentioned in the complaint, then there's no other option but for Mr. Cyril Ramaphosa to appear, not the president. We must also distinguish between these two. It's the person, and obviously also public officials cannot be held criminally responsible. But what the former president did, he summoned Mr. Cyril Ramaphosa in his personal capacity, although he performed a function in official capacity. And that's also why the current president is saying, but I was fulfilling an official capacity for which I'm now being criminally charged under private prosecution. But I mean, it's similar to where a police officer is involved in bribery and corruption. Are we going to summons the provincial commissioner or the minister of safety and security or the police minister? No, we're going to go after that individual, summons him personally and bring him to court. So for me, that is now where the judges, and it's now interpretation, and you can never read into, but from what I saw last week in the court proceedings, the judges were asking a lot of questions from the presidents to clear up and say, why are they saying certain things? Because we also know that there is things in the CPA that allows you to challenge a charge that was put to you. So in this, the interdict would be preemptive of what's going to happen in the trial, and there is interlocutory proceedings that you can use. So if you grant this interdict, you're creating a certain precedent that private individuals can also follow now to say, I'm not going to appear in court. So that is the danger that might also lurk in the back of the minds of the full bench.
Advocate Mpofu would probably, be echoing some of your sentiments. In fact, what he said in his argument is that what we have here is a simple pedestrian charge. A person has been charged and must come to court. So any issues that then the president has, he needs to then address in court. I want you to remind us again, on what grounds does former president, is he accusing the current president of, breaching the NPA Act? I mean, as it pertains to the, nolli prosecute, when you speak to Advocate Billy Downer and journalist Karen Moore, it kind of is quite clear. But here, the grounds are not so clear. And I think that's what a lot of people are struggling with, particularly as it relates to not having, the president's name on that particular, nolli prosecute.
No, the thing is and the NPA, I think somehow they sort of half muddied the water when they said the nolli prosecute certificate pertains to everybody that's mentioned in the complaint affidavit. And unfortunately, our current president's name is mentioned there. And that's why I mentioned earlier about you have your perpetrators, your accomplices, and your accessories after the fact. Now, I think the former president is going after the current president on the crime that he was an accessory after the fact, because there was a crime that was committed allegedly around 9 August 2021, and then he notified the president's office, listen here, this is what's currently happening, you need to intervene. And the president then did not intervene. Now, also, in our law, and it's been for decades, it's been like this. You can commit a crime by doing something, or you can also commit a crime by doing nothing. What they refer to as omissio and commissio. Commissio is the one where you do something, omissio is where you do nothing. So I think the former president is saying that the president, although he was now alerted to the fact that a crime was committed, he did nothing as the president of the country that swore to uphold the Constitution. And then when we talk about upholding the Constitution, now you look at Section 34, Section 35, where it says everybody needs to get a fair trial and all those types of things. Now, we speak in that arena there. But now for the former president to say that, okay, the president did nothing, a commissio, omissio, he did nothing, and that's why he's a necessary to the fact, is also now like, then we will say that the legal question that pops up is that, does every citizen in this country have a legal duty to act when a crime was committed? And that is also one of the questions that the full bench has to answer. Was there a duty on the president when he was made known, or it was made known to him that a crime was committed or being furthered, to act? And if we say that answer is yes, then obviously we're in a different frame of the proceedings now.
Let me squeeze in one last question. So, if it goes unfavorably for President Ramaphosa tomorrow, former President Zuma expects to see him in court on the 19th. What happens if Ramaphosa does not appear on the 19th?
Obviously, if he doesn't appear on the 19th, it's simple. A warrant of arrest should be issued, and then the judge or the magistrate who hears the matter, I think it's a judge that will hear the matter, can then say the warrant will be held over, maybe until a future date, maybe say the 7th or the 14th of February. I'm just now using hypothetical dates. And then if he doesn't present himself, then that warrant becomes final, and then they would send it out for circulation. So wherever a law enforcement agency sees or encounters the current president, then they can arrest him because there's an arrest warrant. But if he appears on the return date of the warrant, and he can give the court good enough reason why he did not appear on the 19th, then he will be excused for his non-appearance. That happens on a daily basis. Or if the court feels like on that return date, we're not happy with your excuse, then they might give him a fine or a short form of imprisonment, normally like something like 3 months, depending on the judge who's hearing the matter. So a warrant of arrest. So on 19 February, if tomorrow the court says, we're not going to grant that interdict, you must appear on the 19th, then on the 19th, Mr. Cyril Ramaphosa must appear, not the president. We must just make that clear distinction. The person must appear. So people, we know it's difficult to separate these two personas, but we have to separate them.
All right. Thank you so much for that clarity and explanation. And that was Elton Hart from the University of Johannesburg's Law Clinic.